The confirmation of charges hearing in the case of the prosecutor versus Abdallah Banda Abakaer Nourain and Saleh Mohammed Jerbo Jamus at the International Criminal Court was held at the seat in The Hague on Wednesday, 8 December 2010. The pretrial chamber assigned to this case consists of 3 judges: Judge Sylvia Steiner, Judge Sanji Mmasenono Monageng, and Judge Cuno Tarfusser, presiding judge. Abdallah Banda Abakaer Nourain and Saleh Mohammed Jerbo Jamus are charged with 3 counts of war crimes, allegedly committed during an attack carried out on 29 September 2007 against the African Union mission in Sudan, a peacekeeping mission stationed at the Military Group Site Haskanita in North Darfur. The prosecutor alleges that the attackers killed 12 and severely wounded 8 soldiers, destroyed communication facilities and other materials, and appropriated property belonging to the AMIS. The hearing was held in the absence of the suspects, who waived their rights to be present at the confirmation hearing, in accordance with Article 61 of the Rome Statute, the founding treaty of the International Criminal Court. Pursuant to the rules of evidence and procedure, the court officers read out the charges against Mr. Jerbo and Mr. Banda.
On 29 September 2007, at the MGS Haskanita in Haskanita village, Kadada locality in North Darfur, the Sudan, in the context of an associated with an internal armed conflict, Mr. Banda and Mr. Jerbo, together with GEM Splinter Group, SLA Unity, and SLA Abdul Shafir forces under their command and control, acting pursuant to a common plan and orders issued by them, jointly with their forces, attacked the MGS Haskanita and killed 12 AMIS peacekeeping personnel and attempted to kill 8 AMIS peacekeeping personnel with the knowledge that they were 1 personnel involved in a peacekeeping mission established in accordance with the UN Charter, and 2, taking no active part in hostilities and thus entitled to the protection given to civilians under the international law of armed conflict, thereby committing a crime in violation of Articles A2C1 and 25.3a and 25.3f of the Rome Statute.
For the Office of the Prosecutor, SFL, Senior Trial Attorney, addressed the Chamber.
On the 29th of September, in the morning, these forces in Dalil Babika were attacked by GOS forces, causing them significant loss of life and equipment. Within hours after this attack, the commanders of these rebel forces, including Banda and Jerbo, held a meeting in Dalil Babika, in which they agreed amongst themselves to attack the AMIS forces stationed in Haskanita. Hours later, these 2 commanders, Banda and Jerbo, led their respective forces and carried out a violent attack on the AMIS base in Haskanita, killing 12 AMIS peacekeepers and injuring 8 others. They destroyed the camp, looted 17 AMIS vehicles, fuel, money, and other personal items. Your Honors, it is for their roles in this attack that the prosecution charged them with the charges that have just been read out by the legal officer. Your Honors, Banda and Jerbo were the undisputed operational military leaders of their respective rebel groups. And it is clear that these groups were organized and disciplined, such that the groups could not and would not have carried out the attack without the authorization or knowledge of their leaders, Banda and Jerbo. But, Your Honors, the suspects also made statements that show that they indeed participated in the attack. And these statements are quite important and need to be considered. And Your Honors, I would just refer to a few. I have made extensive references to statements attributed to these commanders, which explicitly state that their two groups were going to attack the MGS Haskanita. Additionally, we draw your attention to the statement that was made by Banda in Jebel Adola when some of his rebel forces attempted to escape with one of the vehicles looted from the MGS. And Banda stated, "You cannot take away a vehicle which my people had given their lives for." These statements clearly indicate that Banda and Jerbo participated in the attack itself. Your Honors, the prosecution's evidence is clear and shows that Banda and Jerbo planned the attack on the MGS. They ordered their troops to carry out the attack. They also personally led and physically participated in the attack itself. As such, there is no other conclusion other than to hold them responsible for the crimes charged and to commit them to trial. In addition to the direct evidence of their direct involvement in the attack, the factors identified clearly point to their involvement, in particular the individual utterances and also the untold benefits that accrued to them as a result of carrying out the attack. For all these reasons, and in view also of the fact that the defense have considered that the threshold of proof has been met, we humbly ask Your Honors to confirm this case and to commit Banda and Jerbo to trial. I thank you all, Your Honors, for your attention.
Representing 89 victims recognized by the court, 4 legal representatives of victims, Akim Akimbote, Brahim Kone, Jeffrey Nice, and Helen Sisse, delivered the views of their clients.
And so I invite the chambers to confirm the charges has brought and laid before these chambers. That will be all.
I would first of all like to remind you of the interest we have in this court and the hope that the victims have with regard to this court. This hearing is a decisive stage in their quest for justice.
There is nothing in the statements of the two witnesses whom we represent that would counter the argument that these charges should be confirmed. And we look forward in due course to cooperating with the court in every conceivable way to make the involvement of these victims an additional benefit to these proceedings.
Conformément donc.
In accordance with the stipulations in the decision of the pretrial chamber concerning victims' participation in this hearing on the confirmation of charges, and with regard to the scope of the modalities of their participation that the pretrial chamber has affirmed and elaborated on, I will now try to express some of the concerns and views of the victims from Senegal, Gambia, Botswana, and Nigeria. And I, as well as my colleague Maître Kone, have been designated as representatives for them. I apologize for being lengthy. I will give references for the victims in Nigeria, and Mr. Kone and myself have been designated as their representatives now, but I believe that it's important that these victims can be recognized and that they can know that they have been represented in spite of the fact that Colonel Abakaer is not present. So this is important. The victims I represent believe that a rapid decision has to be made following this hearing on the confirmation of charges so that we can give them justice. They want to be able to understand that the suffering they were subjected to, they want to understand that the death of their family members wasn't a useless death. Thank you.
Mr. Jerbo and Mr. Banda are represented by the defense team led by Defense Counsel Karim Khan.
At the outset, I would join on behalf of Mr. Banda and Mr. Jerbo with the final comments and submission of my learned friend, Madam Sisse. We do move and request the pre-trial chamber to deliver a rapid decision on this matter as soon as you're able to consider the evidence and make a decision. That is notwithstanding the fact that the rules require that a decision be rendered within a maximum of 60 days. Now, Your Honours, the motivations and the views of the defence are accurately detailed in the joint submission. Paragraph 8 emphasises that the defence and the prosecution do not for a moment seek to arrogate to themselves the critical decision-making power of the pre-trial chamber. This filing was not born out of disrespect or a failure to understand the important role of the chamber. It was born out of a desire for economical judicial proceedings and an understanding from the defence point of view that confirmation is not a trial. And the very conception of confirmation allows the prosecution to rely in totality upon a summary of evidence or written statements, and they're not obliged to call live viva voce witnesses to the courtroom for their credibility to be tested. That being the case, the defence made the submission that was filed on the 19th of October that Your Honours have seen before. Now, this agreement does speak to the material facts alleged in the DCC. That's the core issue. That is not to say that the defence say that the prosecution theory is correct. Indeed, far from it. The defence view is that there are many misconceptions and errors and fallacies that infect the prosecution theory of the case. But, Your Honour, that's not a matter that is determinative at the confirmation stage. If Your Honours decide, consistent with the joint agreement, and bearing in mind the evidence that's been put forward by the prosecution, to commit this case for trial, these are issues that will be tested in due course and ultimately be decided by a trial chamber of this court.
Within 60 days after the last submission of parties and participants, Pre-Trial Chamber 1 will determine whether or not there is sufficient evidence to establish substantial grounds to believe that Mr. Banda and Mr. Jerbo committed the alleged crimes.